All right, good day, Leonard Silks and colleagues. On behalf of Tobina Erojikwe, the chairman of Nigerian Bar Association Institute of Continuing Legal Education, I respectfully welcome you all to day 5 of this 7-day course on debt recovery and asset tracing. So today's session will focus on the use of receiverships for debt recovery, and to do justice to this very important topic is no less a personality and a very senior and experienced practitioner in the person of Mr. Seyi Akinwumi, a fellow of Brightpan. So before I yield the floor to Mr. Akinwumi, please permit me to read an abridged version of his citation, and thereafter I will do a bit of housekeeping before yielding the floor to Mr. Akinwumi. So Seyi Akinwumi is a corporate lawyer with a career spanning almost 4 decades of active practice. His areas of specialization include business turnaround strategies, insolvency law, energy law, and sports law. He successfully balanced a thriving law practice with an illustrious tenure as a sport administrator, having served as the first 2-term first vice president of the Nigerian Football Federation, NFF, and concurrently leading the internationally recognized top 500 listed law firm, Akinwumi and Busari, as a partner alongside other distinguished partners, including a senior advocate of Nigeria. Within the legal profession, Mr. Akinwumi helped to pioneer the change of the face of law practice in Nigeria by leading the establishment of the Business Recovery and Insolvency Practitioners Association of Nigeria, BRIPAN, now recognized by our Companies and Allied Matters Act 2020. He was also in the forefront of the clamor for the establishment of MBA's section on business law, which most of us know as MBA SPL, now entrenched in the landscape of the Nigerian Bar Association, and also through his efforts, his Young Lawyers Empowerment Company, the Law Events Limited, established a Young Lawyers Training Program in 2007, which has now metamorphosed into the Young Lawyers Forum of the MBA. Mr. Akinwumi is a partner in the firm of Akinwumi and Busari LP. He was the founding secretary general or general secretary and later president of the Business Recovery and Insolvency Practitioners Association of Nigeria, BRIPAN. He was also the first chairman of the Committee on Banking, Finance, and Insolvency of the NBA section on business law, NBA-SBL. Ladies and gentlemen, I present to you Mr. Seyi Akinwumi. But before he comes up, please just permit me to do a bit of housekeeping. I reckon that most of us will have so many questions to unleash on our presenter in the course of the presentation. So I'll admonish you to keep your gunpowder dry. We won't want to interrupt him and make him lose his line of thought. So please keep your questions coming. Use the Q&A tab, and at the end of the presentation, we'll try as much as possible to take as many questions as time would permit. So without further ado, please permit me to yield the floor to our presenter, Mr. Seyi Akinwumi. Sir, you have the floor. Thank you.
Good afternoon, everyone. It's a real honor and pleasure to be part of this session. I'd like to thank Kubi and also the MBA team for all the training that they're doing. They don't realize how important this sort of thing is. It wasn't always like this. The older ones, maybe I'm giving away my age, but the older ones will tell you we didn't always have it like this. So the younger ones who are on here today, they're a very, very lucky generation. That being said, I'd just like to go straight into the presentation itself. And please, if you have questions, put them to me at the end of it. I can't guarantee that I know everything. I only know what I know, but I'll do my best to respond appropriately. And if I can't do it today, if I have to run research and get back to you, I will. Anyway, so we start here. And the first thing I'd like to do is give an introduction. So we'll go to the next slide, please. You know, where in the business world, it's very dynamic, and in the dynamic world of business transactions and financial dealings, especially in the new age, now where we have fintech and all sorts of things, and with all the banking going on, debts play a pivotal role in facilitating growth and expansion and liquidity management for not just businesses. No, go back to the first one, introduction. But also for countries. I'm sure we've heard in the past few months about paying off the debts. And CBN, I think it was last week, said we've paid off all our foreign exchange backlog. So debt is at the heart of business, whether it be individual business, small business, big business. However, the edge cases of debt management often leads to situations where debtors default on their obligations. And sometimes you go after this default and can't get it. So it necessitates the implementation of strategic measures for recovery of that debt. And one of such measures is what we're discussing today. However, in order to appreciate the topic, strategic use of receiverships for debt recovery, it's important that we understand the fundamental concept of debt. What exactly is debt? Understand it's the use of debt in the business world. I'll try to just give you an introduction to that. The essence and mode of debt recovery, I've also introduced you to that you know, sometimes the debt is not paid. And then the pivotal role receiverships can play in that process. Next slide, please. So you ask, what is debt? What is a debt? A debt is a financial obligation where one party, usually called the debtor, owes another, usually called the creditor. And it typically involves, you know, debt, usually involves money borrowed and money repaid or to be repaid. You borrow capital or you take services and you get all this on credit. Now you need to pay back. And that's where the issue of debt comes in. In the business context, debt serves as a vital source of financing for various operational and investment activities, whether it's securing funds for expansion of projects, purchasing inventory, managing cash flow fluctuations. There's a story that, or this thing that you can't grow with your own money, or you can't get maximum growth with your own money, something like that. I don't know. I went to the business school one time for finance for lawyers, and I was taught that. I didn't understand it then, but I think now I do. So if you want to grow at maximum level, you need to take a plunge sometimes. If you don't have the capital, it should not be a limitation. So that in its essence represents a financial obligation by one party to another. And the money must be a sum which has a due date for repayment, and the due date must have passed without the debtor repaying it. So I give you a loan, or First Bank gives you a loan of 100 million, and you're going to pay back by March 31st. And 1st of April comes, and you haven't paid. Then that money is a debt due for repayment. So it's a debt when you take it, but it's a debt due for repayment when you have not paid on the due date. And if you look at the case of Barbados Ventures and First Bank, it's on the slide there, the court held a debt is a liability on a claim, a specific sum of money due by agreement or otherwise. The aggregate of all existing claims against a person, entity, or state, or a non-monetary thing that one person owes another, such as goods or services. We're concerned with the first part of that. That's the money claim. So for a money claim to qualify as debt, the money must be a sum which has a due date for repayment, and the due date has passed. Next slide, please. So now we know what debt is. And it's pretty straightforward, actually. But what is debt recovery? What exactly are we talking about when we say debt recovery? Debt recovery is a situation that, as you will see in the case of Continental Merchant Bank versus Azikiwe, where the court defined it as the process of enforcing a legal obligation to pay a debt owed by one party to another. So you enforce the repayment of that debt from the 1st of April, the example I gave you, because then it becomes a debt owed by you to First Bank. And the concept of recovery, debt recovery, encompasses the set of legal and procedural actions undertaken to retrieve outstanding debts from defaulting debtors. So you have already defaulted. You have to work within the law. And there's also procedural actions. Depending on which jurisdiction you are, the laws will differ, the procedure will differ, but at the end of the day, it's the same thing. You must follow the set of legal and procedural actions undertaken that you undertake to retrieve the outstanding debts from defaulting debtors. And then despite meticulous credit assessment, because all these banks, they have credit risk, they have credit also of departments, risk management, businesses, even at the best of times, with the best of intentions, occasionally encounter situations where debtors fail to honor their payment obligations. And I guess that's the reason why insolvency practitioners and even lawyers have work, because if everybody paid their debts, there will be nothing to recover, and what will happen to us? In such instances, effective debt recovery strategies become imperative to recover all or at least as much of the debt as possible. Now, I'll pause there and talk about the creditor. A lot of the time, the creditors are financial institutions. They may not have done their due diligence or done their work properly. And we've seen this so many times that people give out loans, and it just seems that, did they think about this thing? Because the property that you have as security isn't even registered. Or I've been in a situation where I've seen a situation where the property that was given as security had been repossessed by government because they wanted to have highway through there. And they recovered it under the Land Use Act. So they're now bound by that and have to go after the individual, trying to recover the money. So in essence, that money had no security. So the question then is, what do you do? What do we do? At macroeconomic level, there has been in recent times been a growing concern for the financial health and sustainability of the business of debtor, even in the recovery of debt. And I'll get to that at the end. So the landscape has changed. Before, it used to be just recover the money, I don't care, that's it. But now when there's a possibility of after recovery, you still can let the company recover itself, then that's the preference. So next slide, please. Next slide. Yeah. Strategies for debt recovery. Debt recovery strategies encompass a broad spectrum of approaches. It's not just one. It's designed to facilitate the repayment of outstanding debts. And these strategies include many things. Debt recovery actions, garnishee proceedings on Friday, I believe it was. We listened to Bilal Silk talk about garnishee proceedings and how that can facilitate recovery of debt, foreclosures, liquidations, administration, all sorts. And in all of this, they employ tools such as negotiation, mediation, litigation, arbitration, and so on. But each of these have their own particular rules as well as advantages. And those advantages also, of course, advantages and limitations, of course. But effective debt recovery requires a consideration of all these approaches. You must look at all of them, or as many of them as possible, and weigh one against the other. Sometimes it's a strategic blend of these approaches tailored to meet the specific circumstances of each case that works. So, from a practical standpoint, after documentation such as delivery notes, invoices, agreements, all sorts have been gathered and evaluated, they've written the letter of demand and all of that. And you look at all the documents, the venture where it's there, mortgage, whatever it is that you have. The lawyer would normally send a demand letter to the debtor, introducing the person on whose behalf the debt is to be collected, the amount owed, or current amount owed, where interest has accrued. This would normally be done before proceeding with any of the more involved strategies. And one of the strategies for recovery of debts, particularly secured debts, is known as, next slide please, is known as receivership. Just so that we're able to understand where we are, we need to understand where receivership came from. It's a legal process where the court appoints a person to take possession and control of property, assets, or business in order to protect them and manage their affairs. But that only speaks to one type of receivership. You'll find as we go along that it's not only courts that appoints. But it dates back to days of English common law, where courts would appoint receivers to manage the estates of individuals who were unable to do so themselves. And the concept of receivership was further developed to a situation where the courts appointed receivers to administer the affairs of companies and other entities in financial distress. So it started from individuals. Look, this man cannot run his affairs by himself and is in debt, so somebody runs it for him. and then it evolved. Even in the US, receiverships were a widely used legal tool during the late 19th and early 20th centuries, particularly during times of economic crisis. I'm sure many of us have heard of the Great Depression. And receiverships were used to manage the affairs of failing banks, business and all that. Maybe you might have heard of the FDIC in the US, where it was used to manage the banks in times of the crisis. Next slide, please. So we're coming home, in Nigeria, the primary legislation, as we all know, is CAMA. But first, I'd like to say that in modern times, receiverships are used in a variety of contexts, including debt recovery, corporate restructuring, and even real estate foreclosures and business. I'm proud to say that I was the first, Babisi Ashaye, Prince Babisi Ashaye and myself were the first property receivers in Nigeria when we acted for Lagos State, when the land use charge law was first promulgated. We were the first receivers, and at that time it was very crucial. We would go from big company to big office, big factory to big places, and demand and seal them up if they don't pay and all of that. But I'm glad to say that things have moved since that time. So receivership have got an important tool in the legal system for managing the affairs of distressed companies and protecting the interests of creditors and stakeholders. That is very important. It's not managing only managing the affairs of distressed entities, but it's also to protect the interests of creditors and stakeholders. And I say that because you manage the affairs of distressed entities if you are appointed, and I'll come to you later, a receiver manager. If you're appointed receiver, you can't manage any affairs. Your job is to go and recover. And that's wise, protect the interests of creditors. So, and although rooted in age-long principles of equity, it has evolved over time to be a vital component of modern commercial law. In legal parlance, you say receivership refers to a court or statute supervised mechanism where a receiver manager is appointed to take possession and control of specific assets or business operations to protect the interest of creditors. We will see when I refer to CAMA that in Nigeria, the receiver is the agent of his appointer. In many other places, it's not that, but in Nigeria, the appointed receiver, you are the agent of your appointer. So the primary legislation governing receiverships and managers of companies, including all that can do, is outlined in CAMA. You can go and see that later. All the rights of creditors and other stakeholders. And although there are other rules and other laws that are relevant, for example, the Federal Code Civil Procedure Rules, the Armed Court Act, the primary legislation is CAMA. So it's a remedy available to secured creditors to recover amounts outstanding under secured loan in the event that the company defaults on its loan. You see that I said that it's a remedy available to secured creditors to recover amounts, to recover debts. I'd also like to point out that it's a remedy, if used properly, can be used to recover debts that are not even secured. And I'll come to that, back to that later. So I refer to Black's Law Dictionary. It talks about receive. Defines receive as taking into possession and control, accept custody of. Therefore, receivership can be defined as the debt recovery process where a receiver is appointed either by the creditor to take possession, control, or accept custody of secured assets of the borrower for the purpose of realization of the debt. And that is really one of the main things that we're talking about today. Under CAMA, a receiver can be appointed by a secured creditor or by the court to take control of the assets of a debtor company and sell them to recover debts or to manage them for the benefit of creditors. So when it is to take control of the assets and sell them to recover debts, you're a receiver. When you have the option of managing them, that's for a receiver manager. And it's extremely important that we know the distinction between two. You are appointed receiver, but you can only manage the appointed man. You are given the mandate to manage, and therefore you become a receiver manager. And I hope that distinction is clear, because there have been many times we've had clients come to us and say, we want you to take over the company, it's running, but they're not, there's bad management, and then they give us later and say, we want you to be receiver. And we have to send it back and say, no, you must make this appointment that of a receiver manager. So if you're appointed receiver and you have to manage, please be very careful that you get your mandate right. Now, where you are given the mandate to manage, you also need to be aware that your job entails managing if you have to. And because you owe a fiduciary duty to the company, you need to be very careful on what you're doing, because then it is, you are like a creditor in possession, and you need to be careful about how you manage the company. It doesn't, if it can be managed, it doesn't mean that you must manage, but you need to understand your obligations. And if it's just going to sell, then make sure you're just appointed receiver. Because the receiver, as I said, is an agent of appointed, but owes a fiduciary duty to the debtor company. I must ensure that the assets are properly managed and used to repay debts owed. I'll stop briefly there and just give you a short story that I was told by the party involved. If you go back to the old Companies Act of Nigeria, 1968, you're correct. The receiver used to be an agent of the company. And then there was this receiver who was appointed, and he told me this story himself. It later became the president of ICANN. Anyway, he was appointed by a bank to be a receiver for a company in the East, a brewery actually in the East. And he used to go there from Lagos, and he did the work and asked for money from the bank. And, you know, as usual, it's very, very difficult to get expenses out of the banks. If any banker is here, we are much better now than it used to be. So at the end of the assignment, he then said, I'm taking my fees, which are X%, as well as my expenses. And the bank said, no, you can take your fees, but the expenses you should have taken from the company in the first place, not from our recovery, because you're an agent of the company and not our agent. And he was extremely upset about it. And then shortly thereafter, he was appointed to lead the team to write the insolvency sections of CAMA. The first thing he went for was changing it from being an agent of company to being an agent of his appointer, without even thinking of ramifications. So, ladies and gentlemen, that's how we came to have the receiver being an agent of his appointer. Anyway, going forth, in determining the status of the receiver manager, the Court of Appeal, Pakastina UJC as well, said, referring to a particular exhibit, that the receiver is the agent of the creditor. In this case, the respondent. And as such, if and when he demands and receives money due to the respondent, he does so on behalf and as agent of the respondent and not the first appellant, who was the debtor in that case. So when we speak about receivers, a few things we need to know. In Nigeria, he is the agent of his appointer. He owes the fiduciary duties to the company. He's receiver, but also receiver manager if he's given the authority to manage. So those are extremely important background information you must have when you're going forward with receivership as an instrument of debt recovery. Because if you don't know what you are, what powers you possess, who you report to, then you may run into muddy waters where you're trying to recover the debt. So although the receiver is not expressly defined in statutes, Section 550 of CAMA says that any person can be appointed as a receiver manager, subject to disqualification, subject to disqualification. But now we do know that if you want to be a receiver in Nigeria, you must be a member of certain bodies, chief of which is BRIPAN, Business Recovery and Insolvency Practitioners Association of Nigeria. So I've given BRIPAN a plug there. Anybody who's listening to me and has not registered as a member of BRIPAN, please do so right straight away, because it helps you to expand your horizon. So in Nigeria, receivership is commonly used. It's a commonly used mechanism for debt recovery, especially in cases where the debtor is unable to pay the debts and there's a risk of default. So this paper explores the strategic use of receiverships for debt recovery in Nigeria and focus on the benefits, challenges of this process, as well as the legal framework governing receiverships in Nigeria. Next slide, please. Yeah, so these are some types of debts recoverable through receiverships. There are many more, and the hybrid ones, and also, but I've just sort of focused on these ones. Mortgage debts. This is, of course, where borrowers default on mortgage loans secured by real property. Creditors may seek the appointment of a receiver to manage and eventually sell the property to satisfy the debt. Asset-backed loans, where the loans are secured by specific assets, such as equipment, inventory, or accounts receivable. In the event of default, the receiver will be wanted to take possession and manage his assets on behalf of the creditor. Debentures and bonds. In the context of corporate debt instruments and bonds, receiverships may be initiated to protect the interests of bondholders or debenture holders in cases of default by the issuing entity. What usually happens there is that all these bondholders then appoint a trustee to act on their behalf to appoint a receiver for the secured creditors who are the bondholders or the debenture holders. Trade receivables financing. Receiverships can also be employed in scenarios involving trade receivables financing, where creditors hold security interests over the accounts receivable of a debtor. A receiver will be appointed to collect outstanding receivables, apply them towards debt repayment. Next slide, please. So what's the role of a receiver in debt recovery? We have said that we can use receivership as a tool to recover debt. What is the primary purpose of appointing a receiver in debt recovery situations? The primary purpose is to preserve and protect the value of the assets subject to receivership, then subsequently manage, where appointed manager, and liquidate the relevant assets in a manner that maximizes recovery for the appointer. Please note that I'm not being misogynist. Anywhere you see his, it also refers to her. That maximizes recovery for his appointer. Care of receivers. We're talking about receivership. Says that a receiver can only be properly appointed for the purpose of getting in and holding or securing funds or other property as a means of recovery and for distribution amongst or making over to the person entitled to it. The object sought by such appointment is therefore the safeguarding of property for the benefit of those entitled to it. What does that tell us? That the reason you want to appoint a receiver is so that you can get hold of the property, protect it, the value, and then sell it for the benefit of his appointer, who I've told you before is who he is his principal. If that is the case, you must weigh that objective against all other competing modes of recovery. If I can just go to court, get judgments, get rid of 5A, and go and execute levy execution, is it better? You run the risk of all sorts. Somebody might come and get judgment before you, and then go and execute before you. So many things. But if you have the opportunity where you can appoint a receiver, once it's taken over, then nobody can come ahead of you as far as those assets that are clear. And I'll come to the fixed and floating in a minute that are clearly under the receivership. Because once it's registered, anybody who wants to give a new loan and try to get security will have to do a search at the CAC and find that, oh, there's somebody beforehand. And when you then appoint the receiver, that receiver takes precedence of anybody else who comes subsequently. So if you look at the case of Fashaki and Fashaki, it was held there by Justice Wyford. But as far as I'm aware, there is no single instance in which a receiver and manager has been appointed for a company where it is not for protecting security or properly tied to one obligation or another, which security or property is found to be in jeopardy, or for realizing some loan, whether principal or interest, I guess, or both, upon which there has been default in payments, or where the business has truly collapsed and there is some property or security to be redeemed. So the court tells us clearly, apart from all I've said, that the only time the receiver is for protecting security or property tied to one obligation to another, for realizing some loan, the repayment of a loan, or for where a company has collapsed and there is property to be realized to pay off the debt. So that really is the role of a receiver. And that is what you need to have at the back of your mind. This is my job. And it's quite narrow. Within that narrow sphere, there is, of course, the different work that you need to do, the different kinds of knowledge that you need to have. There are various times you have to source for knowledge from other professions to support you, valuer, sometimes engineers, all sorts of things, but your role is clear. Next slide, please. So, types of receivers. Again, this is general, because within these types of receivers, you have various others. But the general types of receivers are creditor appointed receiver. So when there's security, a creditor can appoint a receiver where within that security there is the power. In the agreement with the creditor, the borrower agrees to make the creditor a secured party and then transforms the loan from a loan simpliciter to a secured loan. And within that security, it's important, I argue, that the creditor must reserve the right to appoint the receiver should the debtor defaults on its obligations. I think it's standard now, we have standard documents that automatically have this there. When we were younger and we were asked to draft, they'll tell the bank will best tell the lawyer to draft the debenture, draft the loan agreement, and all of this. And I remember one particular incident where we were given secure debts to recover, and the receiver was appointed, and he went to take over, and the creditor or the debtor went to court and said, no, we have a right to appoint a receiver. Eventually, we got around it by applying to the courts for the appointment and all that. But I'm just trying to point out to you that it's important to first look at the documents and make sure all the powers that are given to you are powers that were there in the first place to give to you under that document. So we all know as lawyers that you can't give what you don't have. So please don't assume that all the powers given to you are the ones that they have to give. Check yourself, read the documents. It can be tedious, but it's part of the work that we need to do. Court-appointed receiver is typically upon application by the making of a justifiable case. Receiver is appointed through a court order. They function as officers in the court, rather than solely with the creditor who initiated the process. Court-appointed receiverships commonly arise in scenarios where disputes may arise among creditors, between creditors and debtors, or when there is an anticipation of contentious legal proceedings from the outset. So it is here that we earn our pay as lawyers. The times where, like the example I gave you now, you need to think through things properly. Some of those documents are not drafted well, and therefore don't cover everything. I'll give you an example. I was appointed receiver over a company, the assets of a company, and there's specific properties, so the mortgage assets. But on the other assets, there's no debenture. But there was intention to create a debenture, but there's no debenture. And contrary to what happened in one matter that we're in, where the court actually said, erroneously, of course, in my view and in view of most people, that you can infer a debenture. There was no debenture in this case. So what did we do? We went to court and said, there are mortgages in these properties, and there's intention to create a debenture, and the rest of the assets are in jeopardy because these assets, this company has foreign shareholders and directors, and in fact, their main business is strategically placed in a country other than Nigeria. And that the money that is made here has been siphoned through that other company. So we need to appoint a receiver to ensure that process is halted. And the court granted us the order. So we have that on the one hand, as well as the mortgage on the other hand. So we could sell off the properties and also hold the company and act and deliver on receivership. So we have general and administrative receiver. This is the type of receiver created by the debenture trust, deliver all the assets, contracts, and powers of a fixed receiver. So you have the floating and you have the fixed. And one of my colleagues asked me a few days ago about this. That's, you know, so if I have the floating over everything, where does the fixed charge come in? And I give my example, which I'll give now. If you have a debenture, a floating debenture over all the assets of the company, and you take over the company, but UBA has a fixed charge over the generator in that company premises. You can't touch that generator. If they say no, we have already crystallized on this. That generator belongs to UBA. So if you want to manage the place, you either get UBA's permission or you pay UBA off. And it's as basic as that. But you just need to understand the difference between a fixed charge and a floating charge. And those are pointed under the floating, separate from those are pointed under the fixed. So I've spoken about fixed one as well. So next slide, please. Next slide, please. Yeah. So the powers, I've told you that the powers are stated in CABA, so you can go and read 554, 556, and 11th schedule. But I'll just highlight a few things. Once appointed, it is the receiver manager who subsequently carries on the business of the company, because he is in control by law. The company cannot take a decision by itself. It is the receiver manager that will sue on behalf of the company. So you see XYZ Company Limited in receivership, and you have to have that. So in order to properly and strategically use the receiver in a debt recovery scenario, we need to understand the power of the receiver. So I refer us to Intracontractors and UAC 1988. It's a popular case in receivership. In there, it's clear that the receiver becomes entitled to possession of the assets of the company receivership. The floating charges become crystallized. So, before the debts become due, it says it's floating over all the assets. So you can utilize the company, the debtor company can utilize the assets, can exchange, can do whatever it is until it crystallizes and becomes fixed. So you can't do anything with it. Once you appoint the receiver, it becomes crystallized and therefore a fixed charge for all the assets of the company, less EDI, which had prior fixed charges on them. And the director's powers related to the assets charged become paralyzed. This aspect is extremely important because a lot of people get it wrong. When you go in and you want to recover money, the director's powers are suspended by law. So the receiver is the chairman, is the executive director, is the managing director. And that is important to understand. The director ceases to have the power to do any business as regards the company. So usually when we go to court to get an order to protect ourselves when we take over, you also go after directors to say they shouldn't disturb you. Whether it's justifiable or not is a different matter in the scheme of things and the long-term effect. Because once the company owns the assets, can the directors do anything against you? But usually we say the company, the MD in particular, and sometimes the other directors. But their powers have been suspended as soon as the receiver is appointed. 3, the title of the receiver manager prevails over that of other creditors. So he is first in time, unless, of course, like I said, there is a fixed charge that came before he was appointed. I've said the powers of the company and the director are paralyzed as well as the property charged. Once the receiver manager is appointed, he becomes the alter ego of the company, and the powers of the directors to deal with the assets ceases, although the company continues to exist as a company until it's wound up, if it's wound up. Now, at this juncture, a pivotal inquiry arises directly related to the strategic implementation of receiverships. And what's this? It says, you start to think, does a court-initiated receivership automatically confer upon the receiver the dual authority of both a receiver and a manager? I alluded to this earlier. Pursuant to the constitution of powers wielded by a receiver for debt recovery, the Court of Appeal in Ponson Enterprises and others versus Njiga. It's a Court of Appeal matter in 2000. It centered its argument on, or its view on the crucial determination of whether the first appointment imbues them automatically with the managerial powers. And that has gone on in many cases before that time. But it shouldn't have been, because in Wakwe and Odogu, which preceded Ponson, Nemeka Agbo JSC has said that a receiver has no authority to carry on a going concern. And ladies and gentlemen, I want you to take serious note of this so you don't run into muddy waters. A receiver as such, i.e., as a receiver, has no authority to carry on a going concern. His duty is to stop the business, collect the debts by realizing the assets. His duty is to stop the business, collect the debts by realizing the assets. However, a manager, on the other hand, has the powers to continue a business or any going concern, which is why Kama says you're a receiver, but unless you're appointed manager, you have no power to manage. And it might seem very obvious, but I assure you that there are many, many, many cases of receivers who have now taken over as MD of the company when they don't have that power. In the case I referred to, the court affirmed that the respondent's application explicitly sought the appointment of the receiver, simpliciter, and not for appointment of the receiver who also doubles as a manager. It reiterated the fundamental legal principle that the court cannot grant relief beyond what has been specifically requested for by a party, while it may grant less than what is claimed. It cannot exceed the scope. Therefore, it said you cannot be a manager if you are appointed receiver simpliciter. And that power, or those powers delineated, is extremely crucial in debt recovery because it determines how you recover debt. Next slide, please. And that is what I've just referred to. So we're going on to, yes, I just wanted to point out one thing. On the status of a receiver appointed under the AMCON Act, however, the Court of Appeal in Figuret, as AMCON and others, held that such a receiver automatically qualifies as a receiver manager. So where you're appointed under the AMCON Act, the Court of Appeal tells us that such a receiver automatically qualifies as a receiver manager. Let's see, I hear that the matter has gone to Supreme Court, and maybe they'll come up with a definitive response to that. But it does say that if it's not the AMCON Act, the receiver is also a receiver manager. Next slide, please. Now, the meat of it, the strategic use of receivership. We all know that in the under Nigerian law, companies can clearly secure loans and use their assets as collateral. That's not in doubt. In a typical scenario, a creditor's loan money to a company with an agreement for repayment. And that loan is indeed expected to be repaid in line with the agreement that entered into. So you have a creditor granted a loan to a company with an agreement that the principal amount will be paid with interest at the future dates. It may or not, may not involve collateral to secure the payments. If no collateral is provided, then it's deemed unsecured. So unless there's some ingenious way you can go to court and convince the court to appoint a receiver to that company for peculiar reasons, it remains unsecured. However, if collateral is provided, the creditor becomes a secured creditor, granting it the right to recover without money the lent sum by a sale of the collateral in case of default by the borrowing company. Of course, it can be by managing it into repayments, but it means that he has the power to sell. The collateral securing the debt may be fixed to a specific asset or tied and therefore floating on a more generalized class of assets. To enforce the security and recover the loan sums, the creditor must resort to legal avenues to enforce the rights to the proceeds of the sale of collateral. So I refer to section 232 of CAMA, which empowers the debenture holder with the exclusivity to realize any collateral vested in it or to any other party for its benefit, using any of the various means available under the law, including bringing an action against the company or commencing a winding up of foreclosure. But apart from these avenues, receivership stands as another recourse available to enforce that security. Once a receiver is appointed to take control of the defaulting company's assets to enforce security or benefit of the creditors, then, as I said, he is the alter ego of the company. So it becomes, he's actually selling his own assets, or the assets that he is in control of. It can be, the payment can be made either by the parties to the loan or by the courts. But once there's a valid appointment, the receiver is tasked with taking possession, safeguarding, collecting rents and profits, settling outgoing expenses that it believes should be settled, and realizing the security to satisfy the debt owed to the creditor. Where the assets security charge are floating or uncertain, the receiver, if appointed manager, must manage the debtor company. We can manage the debtor company to ensure the timely realization of the sum required to satisfy the debt owed to the creditor. So it's not must, it's can. Apologies. It is clear from the foregoing that receivership plays a vital role in debt recovery in Nigeria, offering creditors a very powerful tool to recover outstanding debts while safeguarding their interests. You have to understand the legal framework, of course, leverage receivership strategically and adhere to best practices. Creditors can enhance their chances of a successful debt recovery in our environment. So next slide, please. I referred to other forms of debt recovery, and I'll just go straight to them. The other forms that we can use, and you need to weigh this against receivership. So why go for receivership? Efficient asset management. In receivership, you appoint a receiver who, especially now, with all this registration and affiliation and BRIPAN and ICANN and NBA and all this, the receiver takes immediate control. He's experienced, he's knowledgeable, and he knows where his powers are, because he's been at this seminar and this presentation that he has heard. The limits of his powers and whether he's a receiver or a receiver manager. So he takes control. So this ensures efficient management and maximization of asset value, which is crucial for debt recovery. When you are suing somebody, in the time in between your filing of your writs and getting the writ of FIFE, the assets may well have completely diminished in different ways. But as soon as you appoint a receiver, he can go in and take over the assets at that time. Expertise and experience. Receivers are typically professionals with expertise in asset management and debt recovery. So if you don't have asset management experience by yourself, then you're at liberty to appoint and to employ professionals who are able to do that you are entitled to rely upon. So you have a valuer. He values the assets. Then when you intend to sell the assets, you can rely on that valuation. It can guide you on what to do. There's some specialized receiverships, and there's specialized fields. And professionals in those fields can be employed to assist the receiver to handle that receivership. So this specialized knowledge, either by themselves or those that are employed, equips them to handle complex financial situations and navigate legal cases effectively. So where we are accountants in BRIPAC, we tend to call on our colleagues who are lawyers. And lawyers amongst us call on accountants. So that is a synergy that works. There's also the valuers. There are also bankers that we speak with. So receivership is a hub of various expertise and experience. 3, protection of creditors' interests. Receiverships prioritize the interests of creditors by ensuring they are managed. So you know you are appointed as an agent of the principal. Your job is to just do that of the principal. So for example, you're winding up. The job of the liquidator is to protect the interests of all the creditors, even though the secured creditor has priority. But his interest is for the whole world, not specifically for his appointed, not the person who brought the petition. Now, legal framework. Receivership operates within a well-defined legal framework in Nigeria. So it provides a structured process for debt recovery. And this reduces the risk of legal disputes and ensures compliance with regulatory requirements. Most receivership litigation ends in settlement, in my experience. And that says a lot for receivership in Nigeria. 4, expedited recovery process. I've compared it with traditional litigation and enforcement processes. Receivers can take swift actions and execute swifter than many other recovery agents using other modes. Flexibility in asset dispositions. Because receivers have the authority to determine the most appropriate method for asset disposition, whether through sale, lease, restructuring, even by opening bids or by private treaty, it gives the receivership flexibility that allows for tailored strategies to maximize recovery based on special circumstances of the case. In many cases, it is those on the ground who see the risk to the assets that can take decisions on how to sell. There was once we had, again, this was one of our BrightPan members. He had receivership and he advertised it in newspapers. He took a whole page. And within 48 hours, there were 3 cases filed against him, 3 injunctions, including from the debtor company. So sometimes you need to move swiftly and take action quickly. So another reason why receivership is good and used is preservation of going concern. In cases where the debtor is a viable business, receivership can help preserve the going concern by maintaining operations and facilitating restructuring efforts. Where we're in one now where the receiver is the place, what is allowing the management to continue running the business. Because the problem was not about mismanagement. The problem that put them in the debt, they are unable to pay their debt or something else. So we evaluated it and we're acting for the company. And it allowed, we spoke with him, it's allowed the company to continue managing it whilst we are moving towards settlement of the entire matter. There's reduced risk of asset dissipation because you are in charge. As in control of a person, you can secure the assets, and dissipation of mismanagement by the debtor is mitigated. Enhanced creditor confidence. The structure and transparency of receivership makes people who want to do business with it be more confident that somebody is in charge. Not when you go there today and then the gates are shut, tomorrow they're open because the business is, stuttering. The receivership, you understand, it is about recovering the company or selling the assets direct. Then, resolution of complex cases also is a benefit. It's easier for a receiver to resolve complex debt recovery cases involving multiple creditors, intricate financial structures, or distressed businesses, because he has the expertise and can bring all of this together under one roof and deal with it. So if you look at it, you understand that there's a lot of benefits. And there's a lot more I could talk about, but I'll leave it at that. All of this is why people use receiverships other than other forms of debt recovery. Next slide, please. I'll just briefly talk to this. This is general law. The appointment of receiver manager by debenture holders over the assets covered in the debenture grants the appointed creditor a favorable position and priority. The floating charge remains flexible until certain events specified in the debenture occur, causing it to crystallize into a fixed charge. So during receivership, all assets are shielded from subordinated, secured and unsecured creditors until termination. However, specific charge created prior to floating charges take precedence. I think I've spoken about that before now. Now, subsequent attempts by judgment creditors to circumvent established creditor ranking against the company are ineffective in disrupting the receivership process. Again, that is why the ring fence of receivership helps you against other creditors. And I'll soon round up. Next slide, please. So yeah, it's not all hunky-dory. Sometimes there are difficulties in receiverships the things that hamper its use, and we can't pretend that all receiverships have come out, in roses, and all the money has been recovered and all that. There are challenges, and in Nigeria, there was time, because when you're appointed receiver, I don't know the reason specifically, but it's probably just based on our general attitude and culture to repayment of debts. There's always resistance, or there's mostly resistance. So you need to go to court to get an order of protection. In fact, it's almost standard now. But we have judicial backlog. Overburdening courts and lengthy legal processes contribute to delays in receivership cases. This backlog results in prolonged litigation, which can undermine the effectiveness of receivership as a debt recovery tool. So you go to courts, say the court give you order that they must not disturb my receivership, they must not this, must not that. And you get the police and everybody and the village, and you go there and take over. And the man calls his lawyer. And the next day he's in court, challenging receivership. And then the court says, come back in 2 months. In 2 months' time, unfortunately, the judge is at the seminar in Abuja. And the court clerk says, we'll give you a date. Another 2 months. And in the meantime, things have started to degenerate. What do you do? So sometimes that can be the case. I've spoken about resistance for debtors. I've spoken about asset depreciation. There are times I just need to move swiftly to deal with that. And if there's this impediment, look, you have an asset that you want to sell, and then the price changes because a new type has come into the market. It diminishes the assets. Or you're busy fighting in courts and the asset is out in the rain. Potential business disruption. So people see XYZ in receivership, and where that negative publicity makes it difficult for the company, the business itself to bounce back. Negative impact on stock, on employees, customers, suppliers, and shareholders. The question as to, should I have kept the employee? Is it their right? Did I meet them there? Are they working for me? All sorts of things. The complexity sometimes of asset realization is also a hindrance. So, like I said, each case on its own, those are general things, but there's certain things you must look at when you're appointed receiver. And I'll speak about that briefly now. Next slide. When a receivership is used for debt recovery, it's important to give consideration to evaluating the financial health of the debtor. You have to decide whether it's viable. Is it viable for me to run this company? Or is it better for me to just sell what I can get and say, look, this is all we can get out of this. Otherwise, we just take on other costs. Is it even viable to enter into receivership? Because you have to pay expenses. All of those things must be considered at the outset, at the stage of appointment. Then 2 is that the assets of the debtor and the quality of security must be considered. You can borrow money and secure the assets, but what kind of assets do they have? You have a floating charge over what I call an amphibious asset. But what use is this? The company cannot pay its debt. gives you floating charge over an asset that diminishes by the day. And you get there, there's nothing. And the owners of the company have disappeared. But there's no money for you to do the business anyway, because you're not in that business. And it costs too much. You then find yourself appointed a receiver, and really, there's nothing for you to do to get anywhere near the kind of money that is being owed. So in some receiverships, the receiver looks like a fool or incompetent through no fault of his. So it's important to assess. There's sometimes, despite the assessment, there's really nothing you can do. So, but that is very important. Now, I'll just round up with brief references to some scenarios. Next slide, please. So, next slide. Yeah. So the first scenario is this. A small business owner grappling with the repayment of a loan facility granted. No, the first one. Back one, please. Yeah. Yep. A small business owner grappling with the repayment of a loan facility granted by a lender faced a critical juncture when the creditor initiated receivership proceedings leading to the appointment of receiver over the company's assets. Rather than opting for immediate liquidation, the receiver collaborated with the business owner to devise a repayment plan, enabling the company to continue operations while settling its debts. This approach proved mutually beneficial to both creditor through the realization of its debt and the creditor whose business successfully avoided liquidation. Scenario 2. So in scenario 1, that receiver then kind of becomes a mediator, manages between both sides, and then everybody goes out, come out quickly clean. Scenario 2, a large lender provided a substantial loan to a debtor for the purchase of a bareboat in a structured asset financing arrangement. A bit more complex, with the payment terms outlined in felicity letters and a build and purchase agreements, as well as charter party. Despite the vessel being built and delivered for use, the debtor defaulted for repayment. Initiating receivership proceedings, the lender appointed the receiver manager over the debtor's assets. However, the debtor company had not only gone into insolvency, but had already had its business license revoked before the receivership commenced, and was facing numerous litigation from unsecured creditors. So the receiver looked at the company and said, look, let me assess this company. What's the point? How much can I get from selling these assets? Will that cover it? James Control, no, it won't. What else can I do? I can't run this without a license anyway. And if I had the license, how much would I get to pay up to debt? But license is difficult to get. But if you had your license revoked, it's easier to get it back. So in his discretion, he decided to sell some assets, not to pay for the registration of the operating license. So he sold some assets, had some money, went to pay all the defaults, got the license back. And instead of attempting to run the company, opted to sell the company's remaining assets and then subsequently sell the operating license and that charter party business. This approach facilitated substantial debt recovery for the lender. So the receiver in this case became a financial guru. Looked at the restructuring of the whole situation, and the same thing that the company had and didn't do. The receiver had the benefit of being able to sell off the assets anyway, to recoup some money, to get the license back, and then sell the assets and the business already in place, and recover the money. Scenario 3, please. Next slide. Next slide, please. Yeah. In another case, the creditor commenced receivership proceedings against the company, and the receiver was appointed with assets. The default in repayment was attributed to a breach by the debtor, who claimed that the alleged breach was caused by force majeure. It's not my fault. I'm not going to do about it. The receiver had taken over the assets of the company and realized that with the litigation that was ensuing, the assets would diminish and neither party would benefit. He entered into an agreement with the then current management of the company to continue to run the specialized company under his supervision in order to maintain value for the assets, which would ultimately be sold upon settlement between the parties. He therefore worked with both parties to reach a mutually beneficial agreement by effectively granting the debtor a moratorium to negotiate with the creditor, enabling the creditor to pay the debt. And in this instance, the receivership was used to efficiently and effectively resolve the disputes between the creditor and the debtor, avoiding costly legal proceedings. Last slide, please. Or the last but one. Next slide. So what do we say? What we say is that stakeholders should prioritize legal clarity and focus on the regulatory framework. And communication is key. And once the receiver comes in, it's not the enemy. His job is to recover the debt that you, the debtor, has incurred and agreed to put his assets as security that if you don't pay, that asset can be used as a tool for repayment. And you have defaulted. It is recommended that policymakers and industry practitioners explore mechanisms to refine and optimize the strategic use of receiverships. I think that's already in place. As I said earlier at the beginning, we're moving towards administration, which is a kind of a cousin receivership. So the administration is a sort of cousin mechanism, except that it thinks it's much more premium is placed on helping the company, the debtor company, survive. But it doesn't mean that receiverships are completely dead. I think it will take a while in Nigeria, although Kama, the newcomer, has tried to move us in the direction of administration. But since it's been propagated, I don't think there will be many administrations. I don't know of many. I've been involved in a couple myself, the early ones, and actually involved in one at the moment. But there are not that many. There's still receivers being appointed just because of the climate we have here, in terms of economic climate that we have here, in terms of our culture. The creditor wants their money yesterday. So in the light of all these considerations, I think that we really need to look at our landscape, appreciate the use of receiverships, know the extent of our powers, and use them to the benefit of the entire gamut of our financial industry. Thank you very much.
Thank you very much, Mr. Akinwumi. Thank you for the very insightful and brilliant presentation. I can see a lot of positive reviews, but before we get to the reviews, I think we have about 25 minutes or thereabout to take some questions. Thank you very much, sir. That was a very insightful and brilliant presentation. I can see at some point, we're over 700 participants and over 645 are still online, which is quite commendable. So, sir, without further ado, we'll just take a few questions and then we'll draw the curtain. So the first question I have is from Grateful Pepple. Grateful wants to know the difference between a liquidator and a receiver.
So you're breaking up.
Can you hear me, sir?
Yes, I can now.
Okay, so
No,
Grateful Pepple. So Grateful Pepple wants to know the difference between a liquidator and a receiver.
Okay. A liquidator is employed to in a recovery in a situation where there's a debt, an unpaid debt. There are a lot of details, but generally, the difference is that the liquidator is responsible to recover money for all the creditors wherever they may be, whilst the receiver is responsible to his appointer. There are various situations. One major one, or one I can just point to, is that in case of a liquidator, although there's some litigation over it recently, that the debts must be specified clearly, exactly. In the case of the receiver, even if you're owing me 100 billion or thereabouts, and you have not paid as or when due, just ₦1, I can appoint the receiver. So but the main difference is that the liquidator wants to wind up the company, i.e., bury the company, really. The receiver, as I've pointed out, a senior receiver manager, can run the company, collect the money, and the company still goes ahead.
Thank you, Mr. Akinwumi. There's a question here. It says, in a situation where a receiver manager has been appointed, can a winding up petition be maintained by a different creditor while the receivership subsists?
Oh, yes. Even the receiver himself can actually initiate a winding up petition if he thinks that's a way to go. But the answer is yes. The only thing, of course, is that don't forget that when the liquidator is appointed and if it's a different person, you still put in your claims and you're secure. Therefore, you still take precedence over the others.
Thank you. Obi Anoye asks, apart from BRIPAN members, are NBA, ICANN, and ANAN members qualified to practice as receivers under CAMA?
Yes.
Okay. Charles asks, it is common practice to have legal mortgage and debentures for nominal values. In the event of enforcement upon default, can such a lender recover the full value, or the lender must upstamp the full value to recover same from the debtor?
Okay, so if you have when you stamp the document to a particular value, you are secured to the level that you stamped and registered for. Therefore, as far as the security is concerned, that is where how far you're secured. The rest of it is unsecured. So, for example, in the question I was asked a few minutes ago, if a liquidator is appointed, you take priority up to the extent that you're secured for, or you join the general pool for the rest, which is why before they appoint receivers, the creditor usually upstamps to the amount they want to recover.
Thank you. Professor Subai from Niger Delta University asks, how do you link receiverships with administration procedure?
Wow, that's a whole paper. But essentially, what the object of both of them is recovery. So while receiverships, especially in the case of receiver simpliciter, is to sell the assets and just get your money back. The object of the administration is a bit more credit debtor friendly. You look at how is it possible to rescue this company, which essentially is what the receiver manager over the past few years have been trying to do. And we've preached in BrightPan for years. In fact, BrightPan used to be called IPAN, Insolvency Practitioners Association of Nigeria. And then we changed it to BrightPan because it was business recovery. So you don't want to just kill the company if you're able to rescue it. And I think the administrative procedure is an extension of that concept.
Thank you. There's a question here. It says, where a receiver is appointed by a court through an ex parte motion, how may the directors or shareholders of a company challenge the appointment of the receiver if their powers are paralyzed?
No, their powers, if they are challenging, they are saying, look, you are coming to my company and you are saying, I cannot work as director anymore. You have the right under the Constitution to oppose that. It's not a stay against your fundamental human rights. You can go to court and say, no, this debenture is faulty or whatever, and therefore this appointment should not have been made. What you cannot do is he's selling to, is offering the land that belongs to the company to Mr. A, and you are saying, I'm offering this to Mr. B, and you're signing an agreement for sale. You can't do that. You don't have those powers. But you can challenge.
Thank you, yeah, thank you. So, Barotimi Agumbiyade says, nice presentation. So he asks, can a receiver manager take control of pending litigations against the company?
Well, it depends on the actual litigation. What is it about? It's not all litigation that you take over. That's why you have noticed to the whole world that by filing your appointments in Abuja, there's a notice at the CAC. So if there's any litigation that comes to your notice as receiver, what I do is look at the litigation and see whether it is one that affects the work I'm doing. But let me give you a funny incident that just happened to me. I was appointed receiver of a company, and somebody came to me and said he supplied something to the company. I mean, the company is owing hundreds of millions, and that he supplied something was less than 10 million, right? 7 or 6 million, something like that, and said I should pay him. I said, look, no, I'm also being owed. You wait your turn. I'm secure. That's why I lectured him and his lawyer on security. And he went to court and asked that he be joined in that suit I filed to get the protective order. And the court granted him. So I was astounded. So, in answering issues about courts is very difficult. But the answer is, it depends. You have to decide whether you want to get involved in that. Because if you get judgment anyway, you can't leave execution until you're out of there. So in some cases I do, some cases I don't.
Thank you, sir. So there's a question here. It says, what is the difference between a fixed charge and a floating charge? And what is the advantage of a fixed charge over a floating charge when the receiver manager is appointed?
Okay, a fixed charge, I thought I explained it, so I probably didn't do as good job as I thought. A fixed charge is where you have the loan and security attached to a particular asset. And that's why I gave the example, maybe you joined it. I give the example of taking over the floating assets of all of the company, but a particular bank gave that same company specific money for the generator. I'm funding this generator. If you don't pay, I'm going to take my generator. So the difference is floating, yeah, fine. There's, it's until it defaults or it crystallizes. A fixed charge, nobody can take anything over that particular asset as is fixed. And then a floating charge, when it crystallizes, becomes fixed over all the assets. And the advantage of a fixed charge creditor over a floating charge creditor, where you're appointed, is that I don't know whether it's advantage or not advantage, because you probably knew of the fixed charge before you took the floating charge anyway, is that the fixed charge is specific to an asset. So you have an advantage as far as that asset is concerned. But only if that asset is worth much more than the rest of the assets, you have an advantage in my view.
Thank you, sir. So someone has asked, what makes a creditor secured? Is it the security document alone or the registration of the security document?
It's the registration of the security document. Well, you have to have the security document anyway to register it. So I would say both. But if it's not registered, then there's no security. It's an intention to create a security. At least if you sign an agreement and you don't go and register it, and then that same debtor signs with Kubi and he goes to register his own, it takes precedence over you because it's first in time.
Thank you. So someone asks, does a receivership order affect third-party interest in an asset acquired prior to the receivership order?
That again, it seems like a very simple question, but it's quite complex. If, for example, it's within 12 months, anyway, within a specified period, if the directors, for example, know that First Bank is coming after them and they want to sell the assets and they want to take over the assets that they've secured, don't forget that last stage is floating. So they have the right to deal with the assets as they like. And then they sell the assets because they know that this receivership is coming. But it is done, I can't remember the exact terms, and I'm sorry, maybe Kubi can help me. Is it fraudulent or what do I say? Anyway, if you can prove that they did it to avoid the receivership, then there are ways that you can claw back. But it's a very complex situation. But there's clawback. There are clawback provisions.
Thank you. We'll just take one or two questions and then call it a day. Afamefuna Magu has asked, can there be more than one receiver or receiver manager at the same time?
I didn't hear you.
So he's asking whether there can be more than one receiver or receiver manager at the same time.
Yeah, just my colleague and I think about to be appointed today as joint receivers. So yes, you can have more than one receiver. You have joint receivers. I've also worked with receivers who preceded me and allowed me to come in. The assets was enough for both of us, and we worked together successfully to do it. So yes, you can have more than one receiver manager.
Okay, before we take the last question, let me just take some of these feedback. You have Afusad Ayodele who says, thank you for the very insightful presentation, sir. And by the way, Mr. King Wumi doesn't like being referred to as sir, so.
Thank you.
So Prosper Ambaka says, thank you very much for the presentations. Emeka Odom says, great and insightful presentation, thank you. Adeboye Adekunle says, very informative and awesome presentation. Thank you very much and God bless you. and I say amen to that. Maureen Ero says, thank you very much. Uchenna Valentine says, very insightful. Thank you very much. Thank you so much. Efudumi Showemimo says, thank you for the session, sir. Lydia Makanwosu, thank you. Idris Abdullahi, thank you, sir, for the insightful session. Aderonke Jaladi says, thank you, sir, for the insightful session. So many comments coming. David Uwe says, very brilliant and insightful. Thank you. Thank you so much. That's Peter Ale. Sadatu Umar said, thank you for the wonderful presentation. Tunde Oremo says, wonderful presentation, beautifully delivered. Thank you. Abel Uba says, thank you for a very insightful and wonderful presentation. There's so many of them. Mfone Mana Etodo says, incisive presentation. Thank you, sir. Yusuf Mokhtar says, thank you, sir. This is indeed a brilliant presentation. We can go on and on and on, but let's take one more question and then we draw the curtain. Mohammed, how do you manage competing interests of various parties, including the debtor, to maximize the benefit of receivership?
Can't hear.
Okay, so Ramat Mohammed is asking, how do you manage the competing interests of various parties, including the debtor?
I think when you wasn't here.
Okay, maybe I should switch on to increase my bandwidth. Let me switch off my camera. Can you hear me now, sir? Okay, so Ramat Mohammed is asking, how do you manage the competing interests of various parties, including the debtor, to maximize the benefits of receivership?
Well, I think that, first of all, your major interests, and I've said repeatedly, is the interests of the creditor. But as a receiver manager, you look at the position of the debtor, just especially if it's retrievable as a business, and also to try and maximize the relationship between the creditor and debtor. And I've always said one thing. Before you came to receivership, there's a relationship between that debtor and the creditor. Otherwise, you wouldn't have had that loan in the first place. So, and for the creditor, if the debtor can pay, he remains your customer. And you make more money in the future from him or from it, as case may be. So the creditor also needs to look at that. And then the debtor has to understand that, look, if you did not, if this company, this bank or creditor, whoever it is, did not advance me this money, I may not be who I am today. My company may not have got, yes, we're in trouble, but we had the benefit of support. And if you look at it in that global manner, you'll then be able to deliver on the best way to deal with it. Unfortunately, in Nigeria, and I must say this regrettably, a lot of debtors see the creditor and the receiver as the enemy. So they will pull up all sorts of stunts, they will do all sorts, and I don't have time enough here to say. But they pull up all stops, to ensure that you can recover. They frustrate you. So your job is to understand who your appointer is and do your best to see if you can help within that context the debtor.
Thank you so very much, Mr. Akinwumi. And this time around, I didn't make the mistake of calling you sir. Thank you so much for the very brilliant presentation and for taking our time to answer all the questions. We also thank you for your presentation, quite in-depth. And I mean, no surprises there for those of us who know you very well. You know, thank you so much for finding time to be with us. You've spent more than 2 hours with us. I mean, you are joined about 20 minutes before the hour, and we are almost 8 minutes to the hour. So thank you so much on behalf of Tobena Erojikwe, the chairman of Nigerian Bar Association, Institute of Continuing Legal Education. We want to profoundly thank you and express our gratitude to you for finding time out of your busy schedule to graciously share from your wealth of knowledge with us. We thank you so much.
I'd like to thank you too, Kubi in particular. Sometimes people find it difficult to acknowledge that those who are younger than them inspire them, but you inspire me. I also like to thank the MBA, for doing this. You see that when there's my profile, the law events, that's what we set out to do. And I'm glad that the MBA is taking it on, and we're going quite a way. I also, of course, have to thank my partners who they are paying me for this time I'm here, but I'm not doing work for them. Mr. Tribusari, Oreo Lajide, and Funke Onukoya. Thank you very much. And my colleagues who helped me on this, thank God, and that's his name. I'm thanking God, but that's his name. And Michael, thank you very much. And God bless everybody.
Amen. Thank you, Mr. Kiwumi. I also want to thank our attendees for their patience and active participation. The comments are still coming in, and I will appeal to Sarah to keep the platform open for a bit after we've drawn the curtains for them to keep sending in their comments and appreciation. Thank you for your time. Thank you for being patient. There are still over 500 people online. We hit more than 700 today. So I want to thank you so much. And we look forward to having you tomorrow. We'll be having Edward Cumming, King's Counsel, and his colleague Tom Stewart-Coates, who will be speaking to us on day 6 of 7 on asset tracing and cross-border debt and asset recovery. So we look forward to having you tomorrow. 2 p.m. is the time, 2 p.m. prompt West African time. So with that, please permit me to draw the curtain now. Have a brilliant evening ahead. Thank you. Cheers.
Thank you.
Bye-bye.